Hello again, my lawyer friends. Rule 1.8.5 is another rule that makes me really happy that I do these videos. Why? Because it is so easy for a lawyer to break this rule with good intentions and then get in trouble. And maybe a lot of trouble. And I feel like a short video here and there can save a lot of careers. So if you like your career, make sure to subscribe to my videos and also buy my book. Rule 1.8.5 is titled Payment of Personal or Business Expenses Incurred by or for a Client. This rule says that a lawyer shall not directly or indirectly pay, agree to pay, or guarantee the personal or business expenses of a prospective or existing client. The idea behind the rule is that allowing lawyers to give money to clients has the potential to cause confusion about the relationship and can create conflicts of interest. There are a few exceptions to this rule, but they're pretty narrow, and they're all designed around normal practices that might come up in the representation of a client. But let's talk about those. A lawyer is allowed to pay or agree to pay expenses to third parties from funds collected or to be collected as a result of the representation, as long as the client consents. Here, the lawyer is not agreeing to personally pay the bill, only to direct the client's money to the third party if money is recovered. Next, a lawyer can agree to lend money to a current client if the client promises in writing to repay the loan and the loan complies with rules 1.7b and c regarding conflicts of interest and rule 1.8.1 regarding business transactions with a client. Both of those rules are covered earlier in this series. If you remember the video on Rule 1.8.1, there are strict disclosure requirements for this type of arrangement. A lawyer may, of course, advance the costs of an action or of otherwise protecting or promoting the client's interests. And repayment may be contingent upon the outcome of the matter. In this case, costs include any reasonable litigation expenses. But this payment can't be a gift to the client. It must at least be recoverable by the attorney on a contingency basis. Obviously, it's a good thing that this exception was included because this comes up all the time in litigation. Next exception, a lawyer may pay the costs of the action or otherwise protecting or promoting the interests of an indigent person in a matter where the lawyer represents the client. So if you undertake a pro bono representation for an indigent client, you may cover the costs without an expectation that you will be repaid. This rule also states that nothing in the rule limits the application of Rule 1.8.9, which deals with purchasing property at a foreclosure sale. And that rule will be covered in a later episode in this series. Now you might notice that these exceptions are very limited, and it might come up that you want to help a client with some personal or business expense, especially if that client is a friend. Well, that's exactly the situation that I mentioned at the start of this video that can get you in trouble. So make sure you understand this rule and its exceptions.